Carried over from the previous video, I ended by saying that we were interested in a legal estate not subject to a trust, described through the Settled Land Act 1925. We say it is not subject to a trust because it is that estate which is before held as a common law interest established in advance of the equitable interest that is subsequently managed through a trust instrument. Now, before we get to here, I'd like to mention the happenings of the time leading up to the 1925 Land and Property Acts. The act that had made it possible for judges to then make the determination as to how these equitable rights to the use of these lands were originally controlled. During the time leading up to the Land and Property Acts, large settlements were difficult to move or be made available for purchase, not only in consideration of their size and subsequent price, and also to the laws of inheritance, I expect, but they immediately had to include most often those who were not held in succession and remainder, or to those who were held in succession and remainder, again to laws of inheritance. Without having more people involved in it I'm just starting to overextend the reading before I read it, so let's get back to it again. With having more people involved in the transaction, of course, would delay or sometimes completely dismiss the potential purchase altogether. As a reminder, please do your own research if this is of interest to you, as I am not a professor of law or have ever attended one single course concerning law. In fact, I have forgotten way more than I have learned along the way. So this is my interpretation of this time of my own research and also discussed with a few others. Now let's continue on with the subject. Another issue concerning these settlements held in a tenant for life, the one holding both legal and equitable interest, was the bargain and sale of the freehold, if not first held or filtered through trustees, which could place the purchaser in liability how the purchase money was to be distributed according to the different interested parties who have a particular state interest in the land. Meaning, once the bargain and sale was complete, all these interests were now against the conveyance, and so now would transfer the liability to this new owner and now holding season. You can begin to see why using trustees, acknowledged through the eyes of the court, became a viable option so as to protect the purchaser of these settlements before held in a tenant for life, namely the Cestui use, so as to be secured through the removal of being liable to any other interest attached to the legal title. Additionally, and so of equal importance as pertains to just speaking to the equitable interest title only, meaning those now subject to a trust, those who were given a right to the use of land, namely, did not hold the common law season, only a possessory right to the use of land for their own profit. Those who worked the land this way, the de facto owners who were responsible for the rent, to put it simply, did not have any obligation to put those profits garnered from the land's use to then vest these profits back into the maintenance and repair of the buildings and other structures, or even build new ones so as to add improvements, because they did not own the rights to the legal title. It served to be of no advantage to the equitable user, since once the agreement met its natural or conditional end, the land went back into the one who held the pre-existing season. Season or season? Season and season, whatever. To those who held the legal estate were often left with cost to repair through the rents they before received, as we can now see not a decisive equitable arrangement or clear profitable venture for the legal estate holder or those in remainder. Then, of course, because those using the interest did not have season, only possession of this type of estate, it was difficult to obtain a mortgage, since not only did it linger the potential that land would be generally in worse shape than when it was first mortgaged, but also the holder of this interest did not have ownership of the freehold. Now, to top it all off, if a non-freeholder estate holder wanted to make changes, perhaps to do repairs or add structures, or perhaps make changes to the use itself, he was held to the determination of the court. Again, costly and cumbersome. Why land and property had to devolve into estates which we now have the right to purchase, made possible through the Land and Property Acts, which essentially made all purchases under the trust for sale scheme to be assumed owners in their own right, so as to be able to transfer these new type estate interests more freely, and this title could now be considered for mortgage without the issues before experience of first getting permission from the courts or include other parties with an equitable interest. And so by having a controlling interest over this type of estate, free from those before legal constraints, one can sell this to another of like for profit. And so it was in most everyone's best interest to maintain and add improvements to the property in anticipation of future profits. Let me read from the Settled Land Act, 1882, Chapter 38, the 45th and 46th year of Queen Victoria. Here's the introduction to this act. It reads, "An act for facilitating sales, leases, and other dispositions of settled land, and for promoting the execution of improvements thereon." We can see how the system needed to evolve in order to ensure everyone, no matter their interest, whether in cession, in immediate possession, or having a right to a future interest, were not placed in an automatic worse position due to the need for laws to be finally settled, so as to be add each interest a modicum of security for each type estate held. So essentially, each type of interest gives each party a right of action concerning their own level of interest concerning each estate interest. Now I know people become extremely angry when their property is taken away for taxes or unpaid mortgages. I mean, why wouldn't they? And then coupled with that, sometimes the capture is disproportionate regarding the amount of time and energy one puts into the property and or the marketable equitable value within the holding itself. I mean, let's use as an example, what if you had $1 million home and either owed taxes for, let's say, $100,000 or was left with this much in a mortgage and no longer could fill the terms of either agreement? Why I say the court only looks to the agreement essentially, not all of the mitigating factors which cannot be heard unless through a different suit against the petitioner. This often requires a different suit other than the one that either the tax department or lending institution has made against the original charge. These organizations are filing a suit against the agreement only, not to do with anything else. Then we have to also contemplate the actions we have as relates to us having the right to remove a person from our property who currently has possession, like a leasee or a leaseholder or some other rental agreement. Are we then also removing them? Albeit, in many cases, they do not add any value to the interest, but even if they did, we want to be secured in our right to have them removed for, let's say, unpaid rent, or if creating too much waste upon the property, or is too hard to deal with, and maybe is threatening. Do you also want swift justice against the agreement and not get caught up in he said, she said arguments? This is why agreements are then secured in courts, so that the correct jurisdiction is administered against the facts of the illegal entanglement. This leads us now into the Settled Estates Act 1856, and like the other one previous, and to keep this video short, we will stop here. Thanks again for listening. Again, like and share. I always have to remind it because I know myself, I watch videos, and even though I like them, I just go, hey, that's great, and then I move on and go, oh. And quite often, I also forget to like or subscribe. So, all right, let's end this video, and let's move into the Settled Estates Act, which will help us better comprehend those interests subject to the Settled Land Act 1925 and those subsequent estates subject to the Law of Property Act 1925.